Breaking news yesterday. The Department of Justice and Internal Revenue Service reached a settlement agreement in Trump versus Internal Revenue Service that established a $2 billion settlement fund. This anti-weaponization fund will likely be used to financially benefit the president, his family, his political allies, affiliated individuals, and related companies and trusts, as well as individuals who were tried for their crimes at this Capitol on January 6, 2021. Moreover, the memorandum in support of the fund establishes that the United States is, quote, forever barred and precluded from prosecuting or pursuing claims against President Trump, related or affiliated individuals, including without limitation, family or others filing jointly, or related companies and trust. This memorandum also states that the United States has no liability whatsoever for misuse of funds into the anti-weaponization fund, thereby facilitating the misuse of funds by individuals who've already shown a complete disregard for the law. Imagine if Joe Biden went this far. Would we have a hearing in the Judiciary Committee? I certainly know we would, and you do too. Will there be a hearing in this committee when it comes to this new slush fund, which I quote, forever bars and precludes from prosecution or pursuing claims against President Trump, related individuals, including without limitation, family, and filing jointly. It's a get out of jail free card forever. And that's the word that's used, forever, for the Trump family from causes of action by the Internal Revenue Service. Worth a hearing in the Judiciary Committee? I certainly hope so. Mr. Chairman, my congratulations to the nominees and their families. Hearings like the one we're holding today are a crucial part of the Senate's advise and consent process. It has never been more important that the Senate exercise this constitutional duty, given that President Trump expects his nominees to be loyal, first and last, loyal to him, not to the Constitution or the rule of law. This is not hyperbole. It is not conjecture. Just last week, President Trump posted another rant on social media, lambasting judges who had the audacity to follow the law instead of catering to his whims. After claiming his Supreme Court nominees have, quote, shown so little respect, close quote, because they ruled against him, President Trump said federal judges should, quote, be loyal to the person that appointed them. Very subtle. In fact, judges take an oath that they will administer justice without respect to persons and, quote, will faithfully and impartially discharge and perform all duties under the Constitution and laws of the United States. Nowhere in this oath does it say that judges are beholden to the president who nominates them. Nonetheless, the president continues to nominate his personal attorneys to serve as judges. Matthew Schwartz, who we'll hear from this morning, the third personal attorney of the president, who he's nominated to a circuit court seat, following the nominations of Emil Beauvais and Justin Smith. For his loyalty to the president, Mr. Schwartz has been rewarded with a lifetime appointment to the second highest court in the land. In fact, he continues to represent the president in court in not one but two pending cases while this nomination proceeds. That includes the appeal of a New York State jury verdict finding President Trump guilty of 34 felony counts of falsifying business records stemming from a $130,000 hush money payment to an adult film star, Stormy Daniels. For aspiring judges not lucky enough to become one of the president's personal attorneys, they can jockey for President Trump's support in another way, supporting his legal arguments. Benjamin Flowers, who is before us today, fits that bill. In one amicus brief, he challenged Pennsylvania's administration of the 2020 election. Why? Because President Trump claims to have lost President Trump lost the popular vote in Pennsylvania and was trying to overturn the results. Earlier this year, Mr. Flowers filed a Supreme Court amicus brief supporting the president's unconstitutional attempt to limit birthright citizenship. This executive order by the president has been rejected by every judge who's considered it. Judge John Kunar, who was appointed by President Ronald Reagan, called it, quote, blatantly unconstitutional. Mr. Flowers has shown repeatedly, whether in government service or in private practice, his North Star is loyalty to President Trump. It's no surprise that his nomination is before us today. President Trump is disappointed in the Supreme Court justices he appointed during his first term. While they are reliable and conservative, they occasionally rule against him. For Donald Trump, this is an unforgivable act of disloyalty. So in his second term, he demands that appointees bend a knee, kiss the ring, and demonstrate blind loyalty. President Trump is now putting forward nominees who've shown they're willing to ignore the rule of law so long as they follow his agenda. That is in direct conflict with what we require of federal judges throughout the history of this country. We should have confidence that jurists will be neutral arbiters who rule without fear or favor. But I'm deeply concerned that President Trump tapped today's nominees because they will, quote, be loyal to the person that appointed them. That was his language. That's what the president's looking for. I yield.